Well, did you think you covered all your bases when you got married out of community of property, when it's no longer happily ever after? Well, that may change. This after the Gauteng High Court reserved judgment in an application that could pave the way for divorcing spouses married out of community of property and without the accrual system to be compensated for what they consider to be their financial contribution to the marriage. But for more on this, I'm now joined by family law expert, Advocate Muhammad Abduroaf. Advocate, thank you for your time and good morning to you. What does this judgment particularly mean? Just give us some clarity and context to what it means.
Good morning and thank you for having me. The matter is still pending in the Gauteng High Court. The question which the court will have to determine is whether or not a marriage out of community property with the exclusion of the accrual regime would allow for a redistribution of assets. Basically, there's another which I depicted now means if the parties divorce, the husband leaves with whatever he has and the wife leaves with whatever she has. The accrual does not apply. But if the judgment is in favor of the applicant, it would mean that one spouse may approach a court and ask the court, despite we being married without the accrual regime, please give me some of my spouse's property or money or assets. So they bring in something that applies to marriages out of community property that were entered into before 1984, the redistribution of assets. So they're trying to bring it into the new regime, into the current law.
So, Advocate, how could this then have a far-reaching effect on the patrimonial consequences of many marriages in South Africa?
It will have huge consequences because, firstly, we're asking the High Court to act as a legislator. That's not his role or the court's role. And secondly, when spouses got married after 1984, they contracted that we are married out of community property without the accrual regime. If the parties divorce or one party dies, that is it. Nobody gets anything from the other party. Here we're asking the courts now to change that, to change what has happened now for the last 8 years to all marriages. And that's not what the parties intended and wish for at the dissolution of the marriage.
Yeah, I think for context, maybe let's bring our viewers up to speed here. This is a case where a wife, of course, of a very wealthy farmer had turned to the court to have Section 73A of Divorce Act 70 of 1979, I know it's a lot of jargon, to rather have that declared unconstitutional. I'm not sure if you have the merits of the case, but just give us context in terms of why this wife had brought this case before the courts.
Basically, what the wife is saying is that when she got married, she was forced into the marriage. Not basically forced, but the family basically told her, you know, nobody gets married into this family without being married out of community property without the accrual regime. So you basically get nothing from this marriage. And when she got married to her husband, she was in love, she was naive, and she was very young. So that is her basis for this. So she's approaching the court, the Gauteng High Court, opening up the doors for many other spouses in a similar position which she was in, stipulating basically that if she now leaves her husband or they divorce at present, she leaves with nothing. But if you have a spouse that was supportive of your spouse, husband or wife, and you assisted that specific spouse in becoming wealthy and developing a further health in life, why at the divorce should you leave with nothing? She is entitled to maintenance, but maintenance is a month-to-month thing. It doesn't allow her any assets and wealth, because we all know the reality of the matter is the mother stays at home, she irons her husband's shirts, she cleans the house, she makes coffee for the guests and stuff like that. And that continues for years. He's still etc. But he's the one that's making money. All the other spouse, I'm using Heath as an example. He's becoming wealthy, he's looking after himself. Why must she now at divorce leave with nothing? And he's the one that acquired wealth and became the wealthy person.
That's interesting because the wife also says it's not just a unique story to her. It happens to many women in South Africa where, of course, they are left out in the cold after a divorce, irrespective of their contribution, to the household, raising children, as you mentioned, contribution to the assets, assisting or empowering the husband to be wealthy and successful while they are more of housewives. So she's saying that it's just not a unique case to her. It seems almost to me that it's also a fight in her argument for many other women in her case.
That's correct, yes. But the difficulty I have with the scenario is when she got married, or when spouses got married, they knew what they entering into. They consulted with a notary public, the person that drafted the anti-nuptial contract, and she explained, or he explained to them, this is how it works. At death or divorce, you receive nothing, but there is the option of getting married with the inclusion of the accrual regime. And they, with full knowledge of how the accrual regime applies and what the benefits thereof are, decided not to enter into an anti-nuptial contract with the accrual regime. Now, 10 years later, after they're married and things have it's not working out during the marriage, now she wants to convert her marriage into a marriage with the accrual regime. Technically, we apply the word redistribution of assets here, which I think will not be fair to many parties, because that was the understanding during the marriage, that you are married out of communal property with other accrual regime, and at divorce, you are leaving with whatever you came in with. And the opposite applies as well, because tomorrow the husband becomes the home carer, he looks after the kids, and at divorce he says, you know, wife, I know we are married out of communal property with other accrual regime, but I would like to have some of your money as well. Is that fair? Is it, is it equitable? Something to be debated upon.
Absolutely, and I definitely like the fact that you're given the other side, that should it have been the husband, would it have also been fair? I have less than 10 seconds with you, Advocate, but I have to slot in this question to you. I mean, we know that as it stands, the law, or rather the court has no power to exercise any discretion, right, where marriages concluded out of community of property with the exclusion of the accrual system after November 1st, 1984. What's the lesson here for many couples getting into marriage, particularly out of community of property? Briefly, please.
My advice to you, simple. Know what you're marrying, what you're getting yourself into, understand the matrimonial property regime, and while you are married and during the course of your marriage, make sure that you are doing legal things that are applicable to your marriage. For example, if you're a business person, know that there are certain consequences that are applicable to your specific marriage, and know that if you're a housewife and you're not working, save your money, keep your money in the bank account. Don't put it into the household if you know that your husband will not give you anything after the divorce.
Very sound and very clear. Thank you so much. Advocate Muhammad Abduroaf, thank you so much for your time. Family law expert there, giving some sound advice there to, of course, our viewers. And we'll leave our conversation at that. I'm sure we'll be following with this story right here on ENCA.